Good afternoon, everyone. My name is Andy Pushlik, and I'm the leader of the Toronto Labour and Employment Group. And today I'm pleased to be the moderator of this, our latest webinar in the COVID-19 Employment Law series. With the arrival of Labor Day and the unofficial end to summer, we are now restarting our webinar series. These webinars will run monthly until December, and will follow the format that we used earlier this year as we continue to try and provide you, our clients and contacts and friends, with the cutting edge information that you need to use as you continue to manage your workplace during this unprecedented time. One change that you will know that is new is our format. We have transitioned to Zoom, so you can now see the faces behind the slides. Despite this change in format, we still very much want your questions. So please send us your questions during this webinar by way of the Q&A box. Next week will mark 6 months since this pandemic began. We have all learned a lot during that time. Today, our focus is on recapping some of the developments that you may have missed while on your summer vacation. If we look at our next slide, you can see who will be joining us today on today's webinar. My colleagues, Gergely Hegedus, a tax associate in our Edmonton office, Stephanie Chimenti, an employment associate in our Toronto office, and Larissa Workowicz, another of our great associates in our Toronto office in the Labour and Employment Group. We are also very pleased and very fortunate to have with us Mark Hart. Mark is a former vice chair of the Human Rights Tribunal of Ontario, and he will be speaking on what is becoming a more and more complicated issue for our clients, that being the accommodation of family status. So with that, I'm going to turn it over to Gergely and Stephanie, who will begin the webinar by speaking about what has happened with the Canada Emergency Wage Subsidy.
Thanks, Andy. So yes, Stephanie and I will be providing an update on the most recent changes to the subsidy program. Next slide, please. So as many of you know, on April 11th, 2020, Bill C-14 received royal assent, which basically was the bill that enacted the provisions for the subsidy. The subsidy is designed to enable employers to keep employees on payroll, to enable employers to rehire workers that were previously laid off, and to help employers hire new workers during the COVID-19 pandemic. The subsidy was initially in place for a 24-week period from March 15th to August 29th, 2020. However, on July 27th, 2020, Bill C-20 received royal assent, and this extended the subsidy program to November 21st, 2020. It also gave the government the ability to extend the subsidy to December 31st, 2020 by regulation. Next slide, please. So the government periodically publishes updates as to how many applicants have applied for the subsidy. And as of September 6th, 2020, there have been over 1,036,000 applicants received. And the vast majority of those, about 99% of those, have been approved. You can see that from this chart that most of those claims are for under $100,000. However, there have been a few for over $1 million and only 270 claims for over $5 million. And so to date, the amount of the subsidies that have been paid totals $33.71 billion. Next slide, please. I'm going to turn it over to my colleague Stephanie for the next part of the presentation.
Thank you, Gergely. Yes, so as Gergely had mentioned, there's been a number of changes to the program, including an extension to the program that you would have likely have seen over the summer. But one of the big headliners that you would have also seen is the removal of the 30% revenue decline threshold. So this change is effective as of July 5th, 2020. And it basically means that any eligible entity who experienced a decline in revenue, no matter the size, is eligible for some amount of the CEWS. This, of course, greatly broadens the access and reach of the program, which is the intent of the changes. So as I mentioned, the removal is effective July 5th, 2020. So I want to note on the left-hand side of your screen, you will note the additional claim periods that run from July 5th, 2020 until the end of the year, November 21st, 2020. And I'll refer to these as claim periods 5 to 9. This is important because the new rules of the SEUS are largely related to these claim periods. And I say that because the old rules under the SEUS still apply for claim periods which ended before the July 5th date. So just bear that in mind as we continue to go through our presentation today. And next slide, please, Justine. Thank you. So another one of the big headliners that you would have seen is the expanded employee eligibility. Also effective July 5th, 2020, the eligibility criteria no longer excludes employees who are without remuneration for 14 or more consecutive days in an eligibility period. So this means that eligible employees under the SEUS will be defined as someone who is employed in Canada by an eligible entity. So this also now makes the SEUS available to both employees who are on leave with pay and employees who have actively returned to work, again, broadening the reach of the program. Next slide, please, Justine. So thank you. So another one of the big changes that you would have seen is the introduction to the base subsidy and the top-up subsidy. So now, as of July 5th, 2020, there are actually two parts to the SEUS. The base subsidy, which is available to all eligible entities that are experiencing declining revenue. The amount of the base subsidy, however, will vary depending on the scale of the revenue decline. So this change now means that any eligible employer that has experienced a decline in revenue and is qualifying revenue is eligible for some amount of the base subsidy. And the second part to this is the top-up subsidy, which is an additional up to 25% available to eligible entities who have experienced the most adverse impacts to the COVID-19 pandemic. So generally speaking, eligible employers who are eligible for this top-up subsidy must demonstrate a 50% or more decline in revenue over a specified 3-month period. So as I mentioned, this totally redesigned SEUS program greatly broadens the reach of the program, but also with that comes added complexities. So Gergely is now going to take over to discuss how to compute the base subsidy and the top-up subsidy and hopefully work through some of these complexities with you. So over to you, Gergely.
Thank you, Stephanie. So yeah, as Stephanie mentioned, there's been some added complexity to the program as the top-up subsidy and the base subsidy are not calculated in the same way. So this is a chart from the Department of Finance's website, and it shows how the base subsidy is calculated for periods 5 to 9. So you'll see that in period 5, the maximum employee benefit is $677 per employee, and that's calculated by taking 60% of the maximum earnings, eligible earnings of $1,129. So if you have a revenue reduction of over 50%, you get 60% of the maximum earnings of $1,129. If you have a revenue reduction of less than 50%, then you multiply it by a factor of 1.2 for the 5th period. So for example, you'll see in the chart that if you have a revenue reduction of 20% in the 5th qualifying period, then you'll multiply that by 1.2 and get 24%. So you'll get 24% of the maximum weekly benefit or maximum weekly earnings of the employee. So that's 24% times $1,129. And you'll also note that the factor that you use to multiply to calculate the base subsidy also changes from period to period. So for the first 2 periods, period 5 and 6, the factor is 1.2, and then it's reduced in period 7 to 1, and then reduced further in period 8 to 0.8, and then reduced further to 0.4 in period 9. So you can see that basically the government's intention is that it's going to wean employers off of the subsidy, hopefully, as the situation with the pandemic improves. So the maximum base subsidy for period 5 starts at $677, but by period 9, it goes down to $225 per employee. So a pretty significant reduction over time. Next slide, please. Thank you. So as I mentioned before, the top-up subsidy is calculated differently. So the top rate of the top-up subsidy or the maximum amount you can receive is 25%, and that's for employers with a revenue reduction of 70% or more. So for those employers, you'll get an additional 25% subsidy. If you have a revenue reduction of less than 50% in any qualifying period, you don't get any top-up subsidy, but it gradually increases. So if you have a 55% revenue reduction, then you get a top-up rate of 6.25%, and it gradually increases to a maximum of 25%, as you can see in the chart. Next slide, please. So you'll note here that the reference periods for the top-up subsidy are actually different from the reference periods for the base subsidy. So in the previous slide, you'll have noted that the base subsidy, you use the current month. So it would have been as compared to the previous month, same month of the last year, or an average of January and February. But in terms of the top-up subsidy, you look at the preceding 3 months. So for example, for the 5th qualifying period, which runs from July 5th to August 1st, 2020, you'll actually look at the earnings or the revenue reductions from April to June 2020 when compared to April to June 2019. So that's the same 3 months of the last year compared to the preceding 3 months of the current year. Or there's also the alternative approach you can use, which is comparing the preceding 3 months, which is April to June 2020, an average of those months over the average of January and February 2020. So once again, there's an alternate approach and a general approach to calculating the top-up subsidy and the base subsidy, but in terms of calculating the top-up subsidy, you look at the 3 preceding months. Next slide, please. So this chart from the Department of Finance shows the maximum amount that you can earn or receive for the subsidy per employee, combining both the top-up and the base. So you'll note in periods 5 and 6, you can actually earn or receive up to 85% of the weekly earnings, which is $11.29. So previously under the old or the previous program, you could receive only 75% of earnings per employee. But now for periods 5 and 6, you can actually get up to 85%. But you'll see that in period 7, it's reduced back down to 75%. And then in periods 6, 8, and 9, it's reduced to 65% and then 45%. So the maximum you can receive per employee if you receive both the base and top-up subsidy is $959. And that's combining the 60% base with the 25% top-up. Next slide, please. So one more significant change is that they've added elections for the baseline remuneration. So the previous definition of baseline remuneration was from January 1st, 2020 to March 15th, 2020. However, now for, depending on the claim period, you can elect different baseline periods for your remuneration. So for claim periods 1 to 3, instead of the default January 1st to March 15th, you can elect to have March 1st, 2019 to May 31st, 2019 as your reference period. And for claim period 4, you can elect 2 other reference periods. So you can elect March 1st, 2019 to May 31st, 2019, or March 1st, 2019 to June 30th, 2019. And for periods 5 to 9, instead of January 1st to March 15th, you can elect July 1st to December 31st, 2019. Next slide, please. I'll turn it back to Stephanie.
Thank you, Gergely. So in addition to all the other changes, the government has also over the summer introduced what is known as the Safe Harbor Rule. And this was introduced in order to provide fairness to employers to ensure that those eligible entities who have already made business decisions under the old rules in the months of July and August will not receive a subsidy rate lower than what they would have had under the previous rules for the same months. So this means in claim periods 5 and 6, an eligible entity with a revenue decline of 30% or more will receive a SUS rate of at least 75%, or potentially an even higher SUS rate using the new rules for the most adversely affected entities up to 85%. Next slide, please, Justine. So under the new rules, eligible employers must also be aware of calculating their wage subsidy for eligible employees who are on furlough, or as defined as on leave with pay. And this is because the government over the summer introduced a separate rate structure for employees who are on leave with pay. And the result is that beginning in claim period 7, so the claim period that we're in right now, which runs from August 30th to September 26th, the SUS support for employees on leave with pay will be adjusted to better align with the CERB and EI programs. And the intention behind this is just to ensure fairness and equitable treatment for employees on furlough and to provide them with greater transparency about their compensation. Next slide, please, Justine. Thank you. So some other technical changes were made over the summer as well, which Gergely and I are going to touch upon now. And one of those changes that you will see on this slide includes allowing eligible entities that use a third-party payroll administrator to access the SUS. So this means that eligible employers who employed one or more individuals on March 15th, 2020, and allowed a third party with a business number to make payroll remittances on their behalf using their third party's account can access the SUS, but will need to register for their own payroll program account. And this is because each employer still requires their own business number and payroll account to access and apply for the SUS. Next slide, Justine, please. Thank you. So the new rules also introduce a mechanism for eligible employers to access an appeals process for amounts relating to their SUS application. So if an eligible employer disagrees with a decision made on their SUS application, they can apply for a second level of review of the claim application. And once a decision has been made or has been issued and the employer still disagrees with the second level review decision, they may now access appeals all the way up to the Tax Court of Canada. So there is recourse now available if there's a disagreement about your SUS application. And next slide, please, Justine. Thank you. So some of the most other recent changes made to the SUS program is there's a deeming rule now for amalgamated corporations that are now deemed to be the same corporation as in a continuation of each of its predecessor corporations. So the result is that a corporation that's been formed on amalgamation or formed on a wind-up may use or can combine the qualifying revenues of its predecessor corporation in determining its qualifying revenue under the SUS. That said, this change is also supplemented by anti-avoidance rules that apply, which means that where the claim will be denied, where, for example, if it's reasonable to consider that one of the main reasons for the amalgamation was to access the SUS or to obtain a greater amount under the SUS than would have otherwise been available. And I'm going to pass it back to Gergely now to speak about some of the other technical changes to the SUS. Thank you.
Thanks, Stephanie. So another technical change that was mentioned by the government on its FAQ website was that non-cash taxable benefits are not remuneration eligible for the wage subsidy. So that includes value of a standby charge that's a taxable benefit derived because of employment. So that is not considered by the government to be eligible remuneration paid to an employee for the purposes of the subsidy. Thank you. Next slide. So in addition to that, the government stated that non-taxable benefits such as employer contributions to a registered pension plan or a private health services plan, those kinds of contributions are not considered to be eligible remuneration. So as defined in the Act, eligible remuneration is amounts paid to an employee as salary, wages, or other remuneration. So this doesn't include non-taxable benefits. And that's the conclusion of our presentation, and I'll turn it over to Larissa for her presentation on the response benefit.
Great. Thank you, Gergely. So to borrow the words of our Prime Minister, the CERB has served its purpose. With the summer coming to an end, so too is the Canada Emergency Response Benefit. As many of you listening know, the CERB was introduced by the federal government back in March to provide financial support to individuals who are unable to work because of COVID-19. And as you'll see on the next slide, the CERB was first extended back in June, and then on August 20th, the federal government announced a further and final extension of the CERB by an additional 4 weeks, equivalent to 1 additional pay period for a total maximum benefit of 28 weeks. The final pay period began on August 30th and is scheduled to end on September 26th. However, anyone who qualified for the benefit but has not yet submitted their application will have until December 2nd to make a claim in relation to the benefit. But what does this mean for individuals who still are feeling the impact of COVID-19 and require income support after September 26th? As you'll see on the next slide, at the end of July, the federal government announced that those individuals who still require income support after September 26th will be transitioned to a newly strengthened and simplified employment insurance program. For context, the reason why the CERB benefit was introduced in the first place was partly due to the fact that the EI system, as it existed at the time, was not able to handle the volume of applications caused by COVID-19, nor the nuances and complexities of the applications that were expected to be received. Since the CERB's introduction, the federal government has been working to strengthen the EI system so that it can not only handle the current number of recipients of the CERB, but is also able to handle future job losses that are anticipated by a potential second wave of COVID-19, which means that the end of the CERB is expected to be a final end, and going forward, no matter what happens with COVID-19, all income support will be coming through the EI system. And we got more information on exactly what changes have been made to the EI system on August 20th. First, the federal government announced that the number of hours that are required to qualify for EI has been lowered to 120 hours of work. Access to EI is based on the number of insurable hours that an individual has worked in the year prior to their application. And recognizing that many Canadians were unable to accumulate a sufficient number of EI insurable hours, as is normally required as a result of COVID-19, the Canadian government has stepped in and reduced the number of hours that are required to qualify, and is also providing employees with a one-time insurable hours credit of either 300 insurable hours for claims for regular benefits, which would be claims related to job loss, or 480 insurable hours for claims for special benefits. For example, sickness, maternal and paternal benefits, compassionate care, or family leave benefits. And these hours credits will be retroactive to March 15th and will be available for new EI claimants for 1 year. Additionally, new EI claimants as of September 27th will receive a minimum benefit rate of $400 per week or $240 for extended parental benefits, if this amount is higher than what that employee would normally be receiving under the EI program. And regular benefits will be accessible for a minimum duration of 26 weeks. As part of the transition from the CERB back to EI, the federal government has also announced that a minimum unemployment rate of 13.1% will be used for all EI economic regions. Again, this was introduced with the aim of lowering the number of hours required to qualify for EI regular benefits. This measure will become effective on August 9th. However, individuals in EI regions with an unemployment rate that is higher than 13.1% will have their benefits calculated using the actual higher rate. So the intention of the 13.1% threshold is to ensure that individuals living in a region that is lower than that threshold will have their benefits calculated on the basis of a higher threshold. And lastly, the federal government announced that it will be freezing employment insurance premium rates for 2 years. But what about those employees that are not eligible for EI, which was one of the main questions that came out when the CERB was first introduced? As you'll see on the next slide, the federal government has announced 3 transitional benefits that it is planning on introducing and that will become available starting September 27th and for 1 year after. And these 3 benefits are intended to serve the 3 different purposes and reasons why people are requiring income support in this COVID-19 climate. The first benefit that's been announced is the Canada Recovery Benefit. And this benefit will provide workers who are unable to work due to COVID-19, but who are otherwise not eligible for the EI system, with a benefit of $400 per week for up to 26 weeks. The second benefit that has been announced is the Canada Recovery Sickness Benefit. And this benefit will provide workers who are unable to work because they are sick or must self-isolate due to COVID-19 with $500 a week for up to 2 weeks. The third benefit that's been announced is called the Canada Recovery Caregiving Benefit. And this benefit is intended to provide individuals who are impacted by the closure of schools and other daycare and day program facilities with a benefit of $500 a week per household for a maximum of 26 weeks. Now, we don't have much information on these benefits at the time, as no legislation or regulation has been introduced by the federal government, giving us more particulars about how these benefits are going to operate. And more information is expected once Parliament resumes and the federal government has an opportunity to introduce legislation for each of these three benefits. And that sums up my brief update on what's been happening with the CERB and the employment insurance scheme. And I would now like to pass it over to Andy and Mark.
Great, thanks so much, Larissa. So as I mentioned at the outset, we're very fortunate to have Mark Hart with us today. Mark is a mediator specializing in employment, labor, and human rights disputes. And he also provides other alternative dispute resolution services such as investigations and private arbitration or adjudication of cases that touch on employment, labor, or human rights issues. However, before he commenced his mediation and ADR practice, Mark served as a vice chair at the Human Rights Tribunal of Ontario for 12 years from 2007 to 2019. During his time as a vice chair, he conducted hundreds of mediations and hearings, primarily in the employment and labor sectors, and many of the decisions that mark the human rights system currently in Ontario were decided by our friend Mark Hart. So Mark, thanks so much for joining us. This is obviously a very complicated time for employers, and we appreciate you speaking about the issue of family status, which is no doubt going to become even more of an issue now that we have people sending their kids back to school and some people electing to keep their kids at home and continue on with homeschooling. So Mark, I'll turn it over to you.
Thank you very much, Andy. I appreciate your kind words. Really glad to be able to speak to such a large audience, and especially it seems, I looked at the list and there's people from all across the country with us today. So it's great, especially for those on the West Coast who are up very, very early in the morning to, or not too early, but early enough in the morning to attend this. I was listening to the previous presentations, and I was struck by the reference to the wage subsidy as Seuss in terms of reminded me of Dr. Seuss, the children's author, and sort of surreal type of writing in those books. And I think that's appropriate for the time that we have this benefit out there called the Seuss benefit. I'm going to start, Justine, if you could move to the next slide. I'm going to start in terms of discussing the approach in terms of family status accommodation in a couple of different facets. The first one, and I'm sorry for the Ontario-centric focus, but I believe the other provinces have similar amendments in terms of leave provisions in light of COVID that have been enacted there. But the first issue is under the Employment Standards Act in Ontario, or employment standards legislation in your home province. When is an employee entitled to leave under that legislation related to COVID-19 and its impact on family members? So that's the first issue that I'll discuss. And then the second issue that I'll discuss is when is an employee entitled to be accommodated. I've said the Ontario Human Rights Code. I will be adverting to other legislation as well, particularly BC legislation. And I know there's a lot of folks on the webinar from BC, and as well as I'll be talking about the federal jurisdiction because I noticed there's some folks from banks and from the airline industry. So federally regulated employers are here as well. So I'll be touching on that as well. But the issue here is when is an employee entitled to be accommodated under human rights legislation because of family status due to COVID-19. So Justine, next slide. And these are important distinctions to make between the leave obligations you have as employers under employment standards legislation versus duty to accommodate obligations you have under human rights legislation. And that's for two reasons. So the first one is obviously leave under employment standards legislation is unpaid, although we've just heard from Larissa that there are some caregiving benefits as well as sickness benefits that that folks may be able to access, but from the employer's perspective, you're not being required to pay the employee when they're on these leaves. Whereas when we're dealing with the duty to accommodate under human rights legislation, you may be required to pay the employee, notwithstanding that they're not showing up in your workplace in the normal way, and we'll talk about that in a few minutes. So that's one major distinction. The second major distinction, and this is more applicable to Ontario Human Rights Code and those provinces that have specific definitions of family status. So in Ontario and other provinces, including, for example, Alberta and others on the East Coast, family status is restricted to, by definition, parent-child relationships. So the duty to accommodate under human rights legislation in Ontario and those provinces with those kinds of definitions only applies in the context of parent-child relationships or marital relationships, that's marital status. And the parent-child relationship can go both ways, so it can go up or down. So it can be the child of your employee, or it can be the parent of your employee in the context of elder care obligations. In contrast, when we're dealing with leave, certainly under the Ontario Employment Standards Act, and I believe under similar employment standards legislation in other provinces, leave is available to a far broader set of family relationships, and we'll talk about that in just a second. And what I also want to note for those folks who are in BC and subject to the BC Human Rights Code, that is similar in the sense that there's no specific definition of family status in that legislation. And so that has been interpreted to apply to a broad range of family relationship, not just restricted to parent-child. And the same thing applies under the Canadian Human Rights Act in the federal jurisdiction for federally regulated employers. Okay, Justine, next slide. Okay, so I want to start with talking about the Ontario Employment Standards Act. Again, apologize for the Ontario focus, but that's where I live. So under the Employment Standards Act in Ontario, they created something called the Infectious Disease Emergency Leave. So you folks who are operating in Ontario have probably been very familiar with this over the last 6 months. So an employee, in the context of accommodating family status issues specifically, there's a whole bunch of other situations where this leave applies, but I'm focusing on family status issues. So this leave is available when the employee can't work because they're providing care or support for a family member because of COVID-19. And that includes, though it's not limited to obviously, but includes school or daycare closures. And that's specifically written into the Ontario legislation. And as I've said, there's a long basket list of family relationships, siblings, in-laws, aunts, uncles, all of this kind of stuff, or even a person who considers the employee to be like a family member. So it's very broadly framed, far broader than the definition under the Ontario Human Rights Code restricted to parent-child. So that's what I meant by that. This kind of leave recently has been extended in Ontario up to January 2nd, and may be extended further depending on whether we actually get the dreaded second wave in the fall. And then a point that we're going to be returning to, I understand later on, but there are legislatively, you are able to require the employee to provide what is called evidence reasonable in the circumstances. And then it's also qualified further by saying this can be or is to be at a time that is reasonable in the circumstances. So there's a double reasonable, but you can't require the employee to provide a medical note. So I've given you the references there, and I know you've been dealing with this, and we'll talk about this in a little more detail later. Okay, Justine, next slide. So the issue that I want to throw out here for you folks to think about, so under the Ontario legislation, it said an employee is entitled to leave in the event of school or daycare closure. Well, for example, as schools are opening up again, what do you do with the employee who decides for their own reasons that they don't feel safe sending their child to school because of COVID-19 and wants to take a leave under the Employment Standards Act and not come into work? And so obviously that's not because of a school or daycare closure, so it doesn't qualify under that part of the definition of the leave. But the question would be, would it be regarded as providing care and support to the child because of COVID-19? And you can think of perhaps specific instances, if the child has asthma, if the child has a particular immune deficiency or something like that. But what if you just have a hesitant or fearful parent? There's nothing particularly medically unique about the child. They just don't feel safe sending the child back to school in this environment, as I suppose a lot of parents are struggling with. And so that's an interesting question, and I'm sure that we'll be talking more about that when we get into the Q&A session. Okay, next slide, Justine, thanks. All right, so I want to turn now to talk about family status accommodation under human rights legislation. I always start with this. It's extraordinarily confusing because there's 3 different legal tests that apply in different jurisdictions in Canada, and the Supreme Court of Canada hasn't yet sorted out for us which one is the governing test. So for you folks out in BC, what the employee is required to show is a change in a term or condition of employment that results in serious interference with a substantial parental or other family duty or obligation of the employee. This was sort of the original test in the Campbell River case way back in 2004. The Campbell River test came under incredible criticism and thought, I think people in the human rights world thought that the next opportunity BC had to revisit that test, it would be changed. Not so fast. Last year in the EnviroCon case, the BC Court of Appeal doubled down on the Campbell River case and essentially took the position, which is interesting to think about in the context of COVID-19, is, if what you're talking about, what you're seeking accommodation for are kind of normal parental obligations or duties that would apply in the context of any parent, that's not enough to satisfy the test. So it's an interesting thing to think about in the context of COVID-19 and whether the approach would be to normalize COVID-19. So in the example I gave you, the court would say, well, no, a parent's normal fears about sending their child to school would not be enough in the absence of some special circumstance like the child having asthma or like the child having some kind of immune deficiency. Next slide, please, Justine. So for folks in the federal jurisdiction, there's a Johnstone case. Folks may have heard of it. It's quite a well-known case. Established a 4-part test, and I've set it out there. The significant parts of the test, you can read it on your own, but the significant parts of the test is number 2, where the Court of Appeal said that the obligation at issue needs to engage the employee's legal responsibility for the child, as opposed to being a matter of personal choice. And then the 3rd part of the test is significant as well, in terms of it requires, in order to establish the right to seek accommodation, that the employee has to have made reasonable efforts to meet those obligations by searching out reasonable alternative solutions. Okay, next slide, please, Justine. So there's been a lot of criticism of this test as well, both saying that focusing on legal responsibilities imposes too high a burden. And then the second criticism is about essentially shifting the burden onto the employee in terms of the onus to prove basically to self-accommodate, as opposed to the onus that in law is on the employer to prove an inability to accommodate. So those have been the criticisms. Next slide, Justine, please. So that led in Ontario in the Misitich decision of the Human Rights Tribunal to establish a different test as a result of this confusion. And essentially, it looks at a contextual assessment about whether the negative impact of the work requirement, which in the case that we're talking about is just requiring somebody to come into the workplace, results in a real disadvantage to the parent-child relationship and the responsibilities that flow from that relationship. And while the Ontario Tribunal said the employee doesn't have to prove an inability to self-accommodate, the ability of other supports will be taken into account as part of this contextual assessment. And again, in Ontario, it's not clear whether it's the Johnstone test or the Misitich test which governs, because our courts basically are straddling the fence on those two tests right now, and I've given you the site at the bottom. Next slide, please, Justine. So in the context of COVID-19, there are just a couple of points that I wanted to make. So the first one is the issue in terms of the duty to accommodate, the issue as to whether or not, if you've got an employee who says, I can't come into work because of, I need to be at home to care for my child for COVID-19 related reasons. And the example we're talking about is a parent who is not comfortable sending their child either to school or daycares if they're open. So if the nature of the work the employee is doing for you makes it impossible for it to be performed from home, so I'm talking about frontline workers here, and we've gotten used to using that term, then in terms of the duty to accommodate, you may need to accommodate the leave from work, so the employee not showing up to work, but you wouldn't be required to pay the employee. However, on the other hand, if the employee is able to perform useful and productive work from home, then not only would you need to accommodate them not showing up in your normal workplace, but you would have to pay them for working from home. And I've given you one of my decisions where I talk about this. And we've gotten used, I mean, in the current COVID-19 environment, to a lot of people working from home in ways that, you know, when I dealt with cases like this in the past, work from home arrangements, employers would say, impossible, they can't do it, there's no way. We've now learned otherwise through this experience. So I think tribunals would take a very different approach to work from home accommodations post-COVID-19. And then the second variable is the identity of a family member at issue, the question about whether or not the person is a child, a spouse, or a parent. And this makes a big difference in terms of the Johnston test, right? Because the legal responsibility is relatively well defined in the context of children. But in terms of spouses, or especially parents, there's not as much to hang your hat on for an employee to establish they have a legal responsibility to provide care or support for a parent. And that's been addressed in another decision I've cited there in the Federal Court of Appeal, saying, well, maybe we can extend it to look at practical and moral needs to provide urgently needed care and so on. So that is a little gloss on the Johnstone test. Next slide, please, Justine. So we're talking about the issue. So as contemplated in the Ontario Employment Standards Act, and as was the situation last spring, if the employee needs to stay home because the school or daycare is closed, and if the employee can perform useful and productive work from home, then, you know, I think on any test, the employee would need to be accommodated and paid, no matter whether you're BC, federal jurisdiction, or Ontario. The other situation is what about the issue of a parent and the issue of the particular vulnerability of older persons to COVID-19, and the employee is saying to you, I can't come to work because I'm busy providing care and support for my parent. or parents. So, a number of questions I've set out there. Does the parent actually have COVID-19? And if so, what are the circumstances? Does the parent live with the employee? And what ongoing care requirements are there, whether the parent lives with the employee or not? And how was the situation of care and support the parent needed managed pre-COVID-19, and why can't that continue? Those, I believe, are the kinds of reasonable questions you could ask an employee to respond to in terms of a request for accommodation or, for example, a request for leave under employment standards legislation. Next slide, please. And then returning to the issue raised in the context of the employment standards leave, what if the school or daycare is open, but the employee simply doesn't want to come into work because they don't want to send their children, they don't feel safe sending their children there? I think under the Misitich test, I think this would be regarded as a real disadvantage to the parent-child relationship. Under Johnstone, it's unclear to me in terms of how that would apply and the extent to which that issue would engage the employee's legal responsibility for the child. And also, there would be the question about, that's part of the test that talked about alternate arrangements if the employee has the ability to send their child to school or to a daycare that's open, and they're choosing not to, and they're saying we can't come into work because of that. Is that a matter of personal choice as opposed to legal responsibility? And is that a rejection of a reasonable alternative in terms of providing the care that's required? And as I said, under the Campbell River and Envirocon test in BC, I think the answer to this question is no, unless the child has a particular vulnerability in relation to COVID-19, like asthma or some kind of immune deficiency. I think, Justine, I'm at the last slide, so I will stop yakking, and I'll give everybody a time to ask questions. Thank you.
Great, thank you, Mark. And we have a number of questions on a variety of different topics. And Larissa, I think we're going to start with you because something that's come up and we didn't address completely squarely, although Mark, thanks for including some content about what the Ontario government has done with the deemed infectious disease emergency leave. Larissa, can you maybe give a quick overview of where things sit with that leave of absence?
Absolutely. And so we already got a spoiler to this answer from Mark during his presentation, but the short answer is that the deemed infectious disease emergency leave did not end on September 4th, as was originally anticipated. And so to give some context, in May 2020, the Ontario government introduced a regulation that converted employees who were temporarily laid off as a result of COVID-19 to be on a job protected leave. And this deemed leave was originally set to end 6 weeks after Ontario's declared state of emergency came to an end, which ended on July 24th. So 6 weeks after that would have put the end of the leave on September 4th. However, in the afternoon of September 3rd, the Ontario government announced that it would be amending the regulation that introduced that deemed infectious disease emergency leave so that leave, along with just the infectious disease emergency leaves more generally, will continue to be in effect until January 2nd, 2021. Now, what that means for the deemed infectious disease emergency leave is that the clock continues to be frozen on deemed terminations under the Ontario Employment Standards Act, and that employers can continue to have employees away from work or with reduced hours without the risk of facing a constructive dismissal claim. And I saw a question come up with respect to whether this means that temporarily laid off employees have been converted to the deemed leave. The answer is yes, but more nuanced than that. It's that employees just continue to be on the deemed emergency leave. They would have been converted to the deemed leave back when this regulation was first introduced in March. So long as the employee's hours are either reduced or eliminated as a result of COVID-19, they will continue to be on the deemed leave. And consequently, the temporary layoff rules will not apply to those employees and will not apply until January 3rd, 2021, again, assuming that the Ontario government does not further extend or amend this legislation. Right now, what we know is that on January 3rd, that deemed infectious disease emergency leave will come to an end, and the Employment Standards Act's temporary layoff rules and the clock on deemed terminations will once again start to apply.
Great, Larissa, thanks so much for that. Gergely, Stephanie, we're gonna switch gears into the wage subsidy and whether there are any restrictions on what employers can use that subsidy money for.
Thanks, Andy. So yeah, there's no restrictions on what the money can be used for because basically the money's already been spent. You're only getting this use if you've already paid your employees their wages. And so basically you're being reimbursed for those wages. So there's no restrictions on what you do with that money.
Great, thanks, Gergely. So Mark, not surprisingly, lots of questions about what we're supposed to be doing now that we've got this hybrid situation, both in the law and in reality, where we've got some parents who are sending their kids to school and some parents who are not, and how we're going to try and square things away when we do get those requests for family accommodation. So near the end of your presentation, you mentioned about how it would be a bit more of a clearer situation if, for example, the parent had a child who has some sort of medical condition that would be clear to put the student or the child at risk if they were to go back to the classroom. In terms of an employer dealing with that type of a situation, what if you were still at the Human Rights Tribunal, what would you be okay with the employer asking for, or would you be okay with the employer asking the employee to provide in terms of documentation which would substantiate the employee's request for that accommodation?
Right. So I think I'll talk about Ontario and because that's what I'm familiar with. So under the Ontario Employment Standards Act, which we talked about, it does, in relation to the leave provisions, does allow the employer to request reasonable information to be provided at a reasonable time, but not medical notes. So in terms of the Human Rights Tribunal, if we're dealing with a request for family status accommodation, I don't expect that the tribunal, and I would say this is probably applicable across the country, would prevent an employer at a minimum from asking for that kind of information. And I note that in the Misitich case, which sets the strongest test for availability of family status accommodation, the applicant ultimately was unsuccessful because she was not cooperative with the employer in providing information to substantiate her need for family status accommodation in an elder care situation there. So I think, absent, and certainly in Ontario, absent the ability to request medical information, I think it would be appropriate for an employer to request from the employee information about what are the specific circumstances in terms of childcare that are preventing the employee from coming in to work, and to the extent that they're saying their schools are open in that jurisdiction and have made a decision not to send the child to the school, to request an explanation as to why that decision was made and whether or not there are any special circumstances applicable to their child that supports the parent's decision not to send the child to school. And it also, I think, would be appropriate to ask what other supports are available in terms of childcare. If it's a female employee, and if there is another parent, what is that other parent doing? Are they at home? Are they able to care for the children? Are there other options available, within family bubbles to care for the children? So it would be appropriate under any of the tests to ask those questions as well. It's just that if you get to the point of an employee asserting that their child has asthma or their child has some kind of autoimmune deficiency or something like that, you can't go that extra step further and require them to provide medical documentation to support that. I suppose if they already had it in their possession, but I just think the wording of the Ontario legislation would make that an iffy proposition. So I think at that point you need to take the employee's word.
That's great. And Mark, I'm going to stick with you for one more question.
Of course.
And this is one of those great COVID-19 hypotheticals, but you can imagine that as we get closer to hopefully having this vaccine, this could be a situation that comes up. Obviously, so much of how employees and all of us are feeling is informed by the circumstances and how things have evolved. So if you remember when we first started with the pandemic, there was quite a concern about whether or not you could get COVID-19 off of surfaces. And I think that's still an issue, but it looks as though the science now seems to indicate that it's not as much of a risk as it maybe was once thought to be, but still I don't want to downplay it is a risk. Now we're getting to the race to the vaccine and hoping that we're going to have a vaccine, depending on who you read, sometime in Q1 of 2021 or Q2. What are you going to do? Right now, I think that there's a lot of sympathy for parents who are really grappling with, should I send my child to school? But if we get into a situation where the vaccine is now being rolled out and we are getting to a point where some of the politicians are now really reopening the economy, but we have a group of people who, for whatever reason, are not comfortable getting that vaccine and still insist on keeping either their child at home or working from home. Do you think that changes the situation? And now this is a real hypothetical, and so and you can see Mark's smile that we definitely did not prep this question.
No, you did not.
But I'm interested to know, because I could see this coming up.
Oh, for sure. And I mean, you've already seen it. I mean, to me, who is not an anti-vaxxer, I just find it astonishing the reaction and the polling that's been done in terms of the proportion of the population that would be even hesitant to get a vaccine. I'll tell you, the first time this vaccine is available and I can get it, I'll be sticking a needle in my arm because it just solves the issues for personally in terms of going out there. We're talking well into the future here, and things may change. But what I would say, the issues for me, if I was determining a case of this nature, would be what is the availability of the vaccine, and is it reasonably available to the employee and the family members that they come in contact with, right? And then the second part of it is, what is the science around the vaccine, and how safe has the vaccine been demonstrated to be, and what if any reputable scientific literature is out there that questions. So I'm not talking about oh gosh, who's the Jenny, somebody who's the main anti-vaxxer person, McCarthy. I'm not talking about her as a reputable source. I'm talking about, if there's actual scientific literature, and particularly if the literature says that this vaccine either is not as effective or potentially harmful in people who have particular kinds of medical conditions, and the employee at issue or someone in their family or something of that nature has a condition of that kind that makes this an issue personally for them. So that's the kind of thing that I would drill down to. But if it's just somebody who's saying, nope, not going to get the vaccine or have my family get the vaccine because I listened to Jenny McCarthy and I don't believe it, and so on. Honestly, I don't believe that that's something that you would need to accommodate. and maybe that's just my personal anti-vaxxer, anti-bias, or anti-vaxxer bias. But that would be my approach to that. I don't see that as something that is connected to a need, which is the focus of family status accommodation. And I don't see it as something that is reasonably connected to any other ground, for example, creed or religious belief or something like that under the code. I don't see it as being objectively connected to those grounds.
Well, that's really informative, Mark. Thank you very much for entertaining that speculation, and thanks to all our speakers. We've now come up right at 1 o'clock. We certainly want to be respectful of everyone's time. A few of you had asked, will the slides be available? They will. They will be sent on an email shortly after the webinar, and they will be attached to that email. I also want to highlight a few new resources for our listeners. First, our colleague, Allison Walsh, who's a partner in our Edmonton office, she's now hosting a podcast on employment law matters, and some are related to COVID-19 and some are not. And so you can hear from Allison and all of our team on various employment law topics. You're going to be able to access a link to subscribe to that podcast on that email that we are going to be sending out shortly. A second resource and another link that's going to be on that email, so it's going to be a very valuable email. We've just published a document which covers off the things that we talked about today, as well as a few other questions about COVID-19 that you may have missed while you're on your summer vacation. Questions like, should we be getting our employees to sign waivers? And what do you do if one of your employees refuses to wear a mask? You'll get a link to that document as part of that email. So certainly you can also search for it and access it through the Denton's COVID-19 Hub. Lastly, I want everyone to stay tuned for an invite for our next webinar. We have some questions that we will be looking to answer during that webinar, and that webinar will be held on October 16th, 2020. Rest assured, we continue to monitor what's happening with all of the various legal developments related to this ongoing pandemic, and so we'll release the agenda for that webinar in the days and weeks ahead. That's it for all of us. So thank you again for tuning in. We always appreciate your participation and welcoming us into your computer screens. And for all of our speakers, this Zoom experiment worked. Thank goodness. It's not temp fakes. And with that, we say have a good weekend. Thanks, everybody.